7. Your views, our interviews on Spectrum, Radio 1 FM 90.
A very warm welcome. This is Spectrum on Radio 1. My name is Edmond, Kizito, your host. On Spectrum tonight, what are the specific clauses in the Public Order Management Bill that need to be struck out or amended in order to have a law that is acceptable? Political players and human rights activists have for the last 1 month been scrutinizing the proposed Public Order Management Bill and have identified specific clauses that they say are in conflict with the aspirations for greater freedoms. The bill has also been under scrutiny in Parliament through the Legal and Parliamentary Affairs Committee, where several organizations and individuals have presented views. While many people are describing it as a bad bill, police and government insist that it's not a new thing even in developed democracies. They argue that there's no absolute freedom, and that just like power, freedoms without control can be disastrous. Those opposing the bill are intransigent. They are now threatening to have the subsequent law struck off the statute books through a court battle later. They say this law gives police and the minister power to derail the growth of democracy. Another school of thought holds that Uganda has enough laws to deal with public order management and that enacting another law is a total waste of time. On the other hand, some people agree that the law is needed but not in its present form. They thus want it amended by Parliament. So our task today will be to single out those particular clauses that are said to be draconian and to understand their gravity. We will also establish the already existing laws that could be used to deal with public order and also analyze what is happening in other countries, including our neighbors in the East African community. Our guest tonight, Mr. Opiyo, legal consultant at AKIJUL, that's a private consultancy, and commentator on political and social issues. You're most welcome, Nicholas.
Well, thank you very much, Edmond, and good evening to all your listeners and all of you who are viewing us online.
Well, Nicholas, could you outline for us the dangers of the Public Order Management Bill?
Well, let me start from a different point. The fundamentals, the question of whether the country needs a law to regulate the management of public meetings or public demonstrations or public order. Now, it is perfectly right that public order needs to be managed and needs to be managed by the state. So the principle that the right to freedom of assembly, the right to gather, to demonstrate, to petition, to associate, is not an absolute right. It's a derogable right. It's a right whose enjoyment can be restricted. However, that said, the derogation, the limitation to this right must not be arbitrary, must not be crafted in a way as to restrict the enjoyment of the right, but rather to ensure the enjoyment of that right. Because you see, the purpose of providing guidelines or providing laws for the exercise of a right is to ensure that that right is exercised within a particular framework. It cannot be to restrict or to actually deny the enjoyment of that right. So any attempt that will restrict other than expand the frontiers of the enjoyment of a right will most oftentimes be frowned upon. And this bill is one such example. Now, the Constitution is very clear about the criteria for limitations. Article 43 provides that the rights provided for in Chapter 4 of the Constitution, some of which are not absolute, can be derogated in two instances. The first instance is if it threatens the rights of other people. The second instance is in public interest. And indeed, Article 43 goes ahead to define what public interest is. Public interest need not be persecution based on issues of politics. Public interest need not be an unjustifiable or not demonstrably justifiable restriction on a right. So all of these criteria, in my view, this bill offends them. This bill does not in any way meet the criteria for this derogation. So the question is, do we need a bill Do we need a separate law to regulate public meetings? My view is no. We do not need a new law to regulate public order because the current legal structures are adequate. The Police Act, Section 32, in my view, is an adequate provision for the regulation of public order. Now, I'll tell you what Article 32, Section 32 of the Act says. Section 32 of the Act provides that in the event of somebody holding a demonstration, a procession, they have got to notify the Inspector General of Government if that demonstration is going to be in a place that is gazetted. Okay? So if you want to go and demonstrate in Parliament,
you notify the police.
You notify the police. The contention has been, what is the meaning of the word notify? Does that extend to mean permission? Now, that's where the argument is, and that cannot be enough justification for enacting a new law to regulate public order management. Now, that said, there are specific concerns, and I want to make two quick points here. The first point is the question of intent. The second point, which I will come back to later, is the question of constitutionality of this bill. Now, the question of intent, what is the actual intent of government introducing this bill? And I can tell you, it's very clear from the bill. The long title to this bill provides for one intent, and the actual clauses in the bill actually provides for a different intention. The long title of this bill provides that this act is meant to regulate public meetings, define duties and responsibilities of those who organize public meetings, and also specifically outline the functions of the police in regulating public order. Perfect long title, perfect intention. But if you go down to the specific clauses of the bill, this intention does not seem to be the overriding intention across the bill. And I can tell you why. Specifically, Clause 3 of this bill provides that the IGP has control over public meetings. And it goes ahead to define what public meetings are. Public meetings in the bill, in Clause 3, is defined to mean meetings in any public place or public road as defined by the Road and Traffic Safety Act. That includes every road in this country. That includes every public pathway. The second definition of a public meeting is any meeting in which somebody is converging to challenge government policies, to challenge government initiative. To even express support is a problem.
Even to express support?
Yes.
To government policy?
Yes.
Oh.
Expression of support, expression of discontent, you have to get the permission of the IGP. So in other words, discourse, political discourse, which is supposed to be the function of a democracy, the content of those discussions is being regulated by this bill. For me, in my view, that is unconstitutional. It amounts to a political persecution.
Political persecution?
Yes, because the bill says the only other meetings that may not necessarily be public meetings are religious function, occasions that are held annually, and activities of political parties convened to discuss the affairs of the party.
Only the party?
Yes. So for any other meetings outside of those meetings, you've got to ask for the permission of the IGP.
So if a political party has policy matters to discuss,
exactly,
if they have a meeting, they literally have to ask police to come and attend it.
Under the bill,
they're not discussing things that break the law.
As long as there are more than 3 people converging to discuss anything other than what the clause actually provides for, you must seek the permission of the IGP. That is an unjustifiable restriction on the enjoyment of a fundamental right. Besides that, and this is the overriding guiding principle of the bill. The principle of the bill is provided for in Clause 3 again. The principle is public-private partnership, if you like.
Yes.
Okay, the partnership between police, the partnership between the community and authorities in managing public order in this country. Perfectly okay.
Yes.
But that principle is oblivious of the fact that The overriding principle should not be just partnership, but respect for the rule of law, but respect for human rights, the enjoyment of human rights, the enjoyment of fundamental rights. Because if the principle of the bill is merely partnership and ignores a constitutional provision for the enjoyment of the rights of people in this country, that in my view is unconstitutional. That is unconstitutional and can be challenged in a court of law. But besides that, the bill also empowers the police to use firearms in the management of public demonstrations in specific instances, in self-defense, for example. So if a policeman who is fully armed, fully protected with a headgear, with a tear gas canister, with a baton, with a gun in his hand, is confronted by a person who is demonstrating, perhaps with a placard, perhaps with a stone, the policeman is authorized, if he feels threatened, to defend himself using live ammunition.
So a policeman could shoot a man holding a placard saying he was threatening me.
Exactly. What amounts to self-defense is left to the good judgment of a police officer. It could just be words. It could just be writings on a placard. That is an overly broad provision that provides or gives a policeman who is confronted with people demonstrating broad powers that can be subject to abuse. The other provision which I have problems with is the powers of the IGP.
The Inspector General of Police.
The Inspector General of Police. The IGP has very wide and very vague powers under this law.
Wide and vague?
Yes.
Go on.
The fact that the decision of the IGP is not subjected to extensive judicial scrutiny is a problem. Because the IGP, in his own thinking, under this bill, can decide that a particularly planned meeting, a particularly planned demonstration, or a procession might lead to a breach of peace.
Yes.
The bill leaves it to his judgment
to determine
whether to allow that meeting to go ahead or not to allow it to go ahead. Those are very wide discretionary powers. And in that respect, it leaves it subject to abuse, especially in the context of Uganda. The other part is the question of notice, that if anybody wants to organize a public meeting...
Before we go to that, talk about the context of Uganda. What do you mean? It could be abused in the context of Uganda. What do you mean by that?
You see, systems like that presupposes a professional police force, a non-partisan police force, a police force that is well-trained, a police force that is human rights compliant, a police force that values life. All of those values are not in their entirety present in the Uganda police force. If the events of the past couple of months are anything to go by, that a policeman in this country is willing to shoot somebody demonstrating and kill them, that a policeman is willing to humiliate a woman, the dignity of a woman. I mean, you saw pictures of policemen humiliating women to a point of nearly undressing them, to a point of throwing them on pickups like sacks of posho. So a police force that is far from being professional, that is far from being human rights compliant, a police force that is composed of ill-trained and in most cases semi-illiterate foot police officers who cannot write statements at the police post, cannot be given these wide powers. That's the context that I'm talking about. That our police force is far from being a police force. Is far from being a professional police force. Now, let me move on to the next issue, which is the question of notice.
Yes.
See, the very purpose of demonstration is to express either support or discontent.
Right. And it could be spontaneous.
It could be spontaneous. It could be spontaneous. This bill requires that if you want to demonstrate, you've got to notify the police 7 days in advance. And in some cases, not more than 15 days in advance. It therefore removes the possibility of a spontaneous reactionary demonstration, either in support or actually against a particular issue. Take, for example, if the president of say, let's say George Bush is coming to Uganda and there are people who are opposed to, who are opposed to his war in Iraq, they should be able to demonstrate and make sure that their voices are heard by this guy. So they may not know about his presence in Uganda, but then they learn to the media that he's in Uganda. So they have to quickly organize and get their point across. Now, there is no chance of that in this bill. So this bill completely removes the chance of being able to demonstrate spontaneously. But also, more importantly, this bill seeks to make organizers of public demonstrations criminally liable for any wrongdoings that might occur during a demonstration. It essentially shifts the burden of providing safety, which is a function of the police, to organizers of demonstrations.
Yes.
It abdicates the function of police to a civilian, to somebody who may not have the constitutional mandate to protect life and property.
Who does not have the wherewithal, no training, no nothing.
No training, no equipment, no authority. So in a sense, if the police is supposed to provide security for a demonstration and they don't, and that demonstration goes bad, the organizers of that demonstration might be actually criminally liable. So you can see that a lot of the things in this bill is riddled with bad intent. Is riddled with an intention of restricting political space, of restricting the content of discussions. That's the first point. The second major chunk of the argument that I want to make is the question of constitutionality.
Yes.
Our Constitution is a beautiful document. It outlines in Chapter 4 an extensive Bill of Rights. This bill, in many ways, provides drawbacks to the beautiful Bill of Rights that we have in our Constitution, and I can tell you why. The enjoyment, the freedom to assemble and demonstrate is a constitutional provision.
Yes.
It's a constitutional right.
Yes.
It's not guaranteed by the state. It's an inherent right. The state only exists to make sure that these rights are exercised in a responsible manner. So what this bill does, because you see, that freedom under Article 43 is a derogable freedom.
Yes.
It can be restricted.
Yes.
What this bill does is to restrict this right, the enjoyment of this right, beyond what is demonstrably justifiable in a free and democratic society. I can tell you this. The features of a free and democratic society, among others, include the free exchange of views.
Yes.
That people must be able to congregate, discuss government policies, criticize it, oppose it, and have free flow of ideas. What this bill does is it takes away that responsibility, it takes away that right, and puts the enjoyment of that right at the wide discretion of the person of the IGP. So in that sense, that provision is unconstitutional. Secondly,
it contravenes a key section of the Constitution.
It does.
Section 4, which is the Bill of Rights.
It does. It does. Chapter 4, which is the Bill of Rights.
Right.
It does. Particularly on the restriction provided for under Article 43 of the Constitution. So in that respect, the bill is unconstitutional.
Right.
Secondly, this bill defines public meetings to include meetings intended to discuss government policies.
Yeah.
So if you're going to discuss something that is political,
yeah,
something that touches on government exercise of its function, you have to ask for the permission of the police. Now, if that is not political persecution envisaged under Article 40 and under Article 43 of the Constitution, then I don't know what is. This bill squarely seeks to legitimize political participation, and that I think is dangerous for our country. It seeks to legitimize,
to make illegal.
No, it seeks to legitimize political persecution.
Persecution, yes.
Persecution,
right?
And that for our country is dangerous. That, in my view, is unconstitutional. It cannot be allowed to pass. If it does, it will be very unfortunate for this country. Let me also mention, Edmond, and I think this is important, that this bill is not peculiar to Uganda. There are other countries that have regulated public meetings. I can give you the example of the United Kingdom. I was fortunate enough before Chogam to attend a training that was organized, ironically, the IGP was there, that was organized by DFID, in which they brought in to train civil society and the police, to train us on public order management. I was fortunate to go through the Public Safety Act of 2006 of the UK. Beautiful document that provides for judicial oversight, provides for limited powers to the IGP in the control of public, in the control of public management.
Limited power.
Limited powers,
yes.
not unlimited powers. Provides for judicial oversight. Provides for spontaneous demonstrations. Beautiful. What our bill does here is the complete opposite. It seeks to rightfully control public order, but do so in a manner that violates the very constitution that we crafted in this country.
Wow, remarkable. And you say the IGP attended that. Listeners, this is Spectrum on Radio 1. Tonight, what other specific clauses in the Public Order Management Bill that need to be struck out or amended in order to have a law that is acceptable? You've just been hearing from Mr. Nicholas Opiyo, a legal consultant at AKIJUL, also a commentator on political and social issues. Our second guest has just showed up, Miss Sophie Kyagulanyi, research and policy analyst for governance at AKIJUL Uganda. We're going for a break. We'll be back.
We go back a bit. We knew John at the beginning, working for someone else. But he was different. He had vision, saw opportunities. He started working towards his goal, opened his own garage, and worked, learning the hard way. His reputation spread. Trust, consistency, quality. Soon people were coming to him from all parts. He made himself and his whole street prosper, and also helped friends, seeing potential in people and helping them on. But John never shouts about all his success. He's just who he is. Special.
So here's to men like John, who make a difference, who enjoy Nile Special, the rich, satisfying taste from the source. Nile Special. You've earned it.
Not for sale to persons under 18.
Let the sunlight in.
Good morning, sunshine of my life. You look happy today.
I am. I came in here and I saw there was a whole pile of washing to do.
But I thought you didn't like doing the washing.
No, I love it. Anything else you need washed?
Sunlight 2-in-1 with added fabric softener. Smells so good, you want to use it again and again.
Let the sunlight in.
Sunlight 2-in-1. Sunlight clean, sunlight fresh.
Sunlight in. Happiness is all around. Let the sunlight in.
Spectrum on Radio 1 FM 90 is brought to you by Stanbic Bank.
Welcome back on Spectrum tonight. What other specific clauses in the Public Order Management Bill that need to be struck out or amended in order to have a law that is acceptable? Our guests tonight, Mr. Nicholas Opiyo, legal consultant at AKIJUL, also a commentator on political and social issues, and Miss Sophie Kyagulanyi, research and policy analyst for governance at AKIJUL Uganda. You'll be able to call in and contribute to this discussion when that time comes. Sophie, IGP Kyagulanyi said certain sections need to be removed. So that means the government is very sensitive. It's going to give us a good law in the end.
Good evening, our listeners. In response, I think, yes, his comments are on record where he's actually suggesting that if there are any provisions in the bill that will curtail the enjoyment of certain rights, then of course those provisions in the bill need to be changed so that they can allow the enjoyment of rights. But key things here come in. It's not very clear whether the comment is making a comment made on record, especially record of police, and if they are just made as statements to sway a debate and discussion where he was, because this happened when he was in Makerere University at a student dialogue that was convened by the Makerere Law Society, which ActionAid supported partially. And at this dialogue, because of course the students put him on pressure to give his comment and opinion about this bill, and specifically certain provisions, and he was able to say that yes, we accept that certain provisions in that bill will need to be worked on. However, we are yet to see the working on those provisions, because already the police is on record, especially with the Legal and Parliamentary Affairs Committee of Parliament, for having supported the whole bill, the entire bill, including the provisions in the entire bill. But if it's coming out saying that certain provisions need to be changed, then let's wait to see the report of the Legal and Parliamentary Affairs Committee and the revisions they would recommend.
Well, maybe he's seen the light. Men and women are allowed to change their mind.
Which is allowed, but now we want to see the change in the bill itself.
Let's just be fair to the IGP, because I think the IGP is being dishonest. When the IGP is called upon to make a comment on this bill before Parliament, the body that is actually going to discuss this bill,
he defends it vehemently.
And God forbid they might pass it. He defends the bill, justifies provisions, and you see, if you've seen the original copy of this bill, at least the one that I have, there's a handwritten comment by the IGP saying that policemen must be allowed to use firearms. This is on record. The same IGP,
that's from his own
not months later, not days, not many weeks later, appears in a debate at Makerere University, the law faculty, and seems to suggest that what he said in Parliament was actually wrong, and that some of the things in this bill needs to be amended. Now, if he is being honest, I think the best he should have done is to actually ask for a different appointment to appear before the committee to point out the specific provisions that he thinks needs to be amended. He's being dishonest. Because, you see, the only people who are supporting this bill, the person of Kyagulanyi, he's being dishonest. I can tell you. Because if he actually genuinely thinks that some of the things in this bill needs to be amended, the appropriate forum to do that is Parliament. When he appeared before Parliament, he appeared to support this bill in its entirety. 2 days or a couple of days later,
goes to
Makerere. He says, you see
the boys push him against the wall.
So he's being dishonest.
They're very sharp.
He's being dishonest, and I think it's a big disservice to our country. He needs to be a bit honest with himself. But Edmond, secondly, let's not lose the fact that the Constitutional Court made a decision in the case of Mwanga Chivumbi versus Attorney General that impacts on the powers of the IGP in the control and management of public order. This bill is a direct attempt to reverse, not to implement the recommendation of the court, but to reverse the court decision.
And what's wrong?
It's an affront.
It's like football.
Once a court hands down a decision, that decision has to be respected and implemented by the executive branch of government. If a particular section of the law has been declared unconstitutional, you owe it to this country to amend that particular section, strike it off.
Not try to bring it back.
Not try to reintroduce it in a different way. So what this bill is doing is trying to circumvent a court decision, a constitutional court decision, by introducing the same things that the court declared unconstitutional.
And what's wrong with that?
That makes it unconstitutional.
It offends the Constitution.
Does the Constitution say that?
It does.
Yes, it does. It does.
I think it's article, I can get it for you, I don't have it offhand.
You can paraphrase it.
I can get it offhand, but you say that Parliament cannot make a law to vary a court decision.
Yes.
You know, it's very clear.
Yes.
I'll give you the specific article as we go along.
Yes.
That you cannot pass a law to vary a court decision between the parties.
What police and the Ministry of Internal Affairs are doing is illegal. It's unconstitutional.
It is unconstitutional.
They're breaking the law.
It is unconstitutional, and I can bet on this, Edmond. If this bill is passed in the way it is now, the courts will strike it down.
It won't take days.
It will not take days.
All right. Sophie, sometimes police say they respond with equal amount of force. When the rioters, when people begin to demonstrate and they become rioters, they also have to roll up their sleeves and hit them back with equal force.
Equal force, I think it depends here, because if the rioters, for instance, have stones,
yes,
and
police have metal stones,
and probably bullets and guns, and the stones are thrown from all corners of the rioting place, and police just shoots whoever they see. To me, that's
You want them to pick up stones?
No. That's not equal force, and that's not reasonable.
The rioters use force to hit them. You want policemen
No, but the
to pick up
policemen,
stone.
if they just go shooting, then those will be stray. They are not actually applying the equal force treatment.
You want them to pick stones as well?
No. The use of firearms in that situation should be guided, and the Police Act already guides on how they should not shoot in the air as such, but it should be guided how you use a firearm and when you use a firearm, under what circumstances, not in such circumstances. We've had situations of, for instance, people with sticks stemming from, for instance, the central police station to the streets of Kampala and beating up people.
They no longer do that.
They no longer do that, but they used to do that. And when they used to do that, police didn't say anything to them. They were actually attacking people who are rioting, you know. And now, if police now wants to use the same reasonable force, you know, applying it to the rioters who are throwing stones, and then will use the ones with firearms, that cannot be balanced.
So, let me just, of course, I agree with my senior colleague here, but we are blessed that there is jurisprudence defining what is meant by reasonable force. Yes. Reasonable force has qualifications.
Go on, tell us.
It must be what is reasonable in the circumstances.
Yes.
In other words, something that your reaction must be proportionate to the threat that you're facing.
Proportionate reaction.
It must be lawful. It must be lawful.
It must be proportionate and lawful.
And lawful.
Yes.
And lawful. Edmond, this use of force, reasonable force, presupposes a police officer who is trained, who is equipped with protective gears.
Yes.
He has a helmet, he has a shield. Okay? A policeman who has a higher responsibility of protecting the lives of other people than anybody else. So a resort to the use of force must be an exception, not the rule. What this bill provides is the use of force becomes the rule.
That's what it says.
Yeah.
Yes.
In the training that we attended, and I'm telling you that the IGP was
In
there,
the UK.
Edward Ochom was there. In Uganda before Chogam.
Right.
Edward Ochom was there, you know, Grace Turagumaname was there. A couple of senior police for 1 week. The police were taught a 10-stage process of approaching a demonstration. The first step is not showing up with a gun. The first step is not showing up with a baton. That is the last procedure in handling demonstrations. What this bill does is that it makes the last procedure the first.
What are you
But if you're going for a demonstration, you can actually turn up with firearms.
What do? You serve them ice cream or what?
No, you don't serve ice creams. Edmond, the rule of engagement in demonstration, and I'm not an expert in this, but I was part of this training, require one, that if you're approaching demonstrators, you should not provoke them. You should not go in a way as to show that you're in a battle
with them.
But some of these are
So the management of anger now comes in. How do you manage that anger to make them reach a level of discussing and talking? No, the demonstrators' anger.
Right.
Yes. How do you manage that anger? Do you increase it? Because when you appear well clad to fight, they will think it's a battle now. So they also get ready for battling.
You might think they are going to outer space aircraft.
There's another policeman.
Yes.
And now when you say reasonable force, it comes back to you because for them, they're well armored and the demonstrators or rioters
to protect themselves
don't have anything to protect
someone is
themselves.
not going to hit you. It's just to protect the police.
The experience we have seen, not just in Uganda, but everywhere around the world, that in a demonstration, in a volatile situation like that, you're approaching a charged crowd. The first thing you want to do is not to fuel the anger.
Cool it first.
It's to cool it.
Yes. How do you do that?
A beautiful example, I can tell you a beautiful example that happened in Iraq in the very first months of the invasion by the US.
Yes.
US forces were patrolling the streets of Iraq, of Baghdad.
Yes.
What happened is that they were then approached because they had guns, they were well armed, they were approached by an angry mob. What did the commander do? He didn't order his forces to shoot. He ordered them to point their guns on the ground and smile at the guys who were approaching them. Believe me, there was no confrontation.
I should like to see a
guns pointed down, they were smiling and they were very nice.
So they used the most powerful weapon.
They calmed down a very charged crowd. our policemen here cannot point their guns down.
That would be
They can smile back
very
at you.
positive weapon, because these are different cultures,
Yeah.
different because you're talking about people from different worlds.
Exactly. So the first approach must be a friendly approach, must be an approach that doesn't fuel the anger. The second stage of confrontation is a stage of sensitization. You say, guys, look, this demonstration is illegal. I command you in the name of the Republic of Uganda to leave this demonstration.
Yes.
Please disperse peacefully and go back to your places of work or residence.
That's the first, should be one of the first things.
You then progress to a stage where you can be allowed to use not weapons, but rather preventive instruments such as a baton, such as pushing them away with a shield, such as dispensing tear gas. Okay? The use of firearms is the last and 10th stage in riot management. And the police needs to adopt that stage and not come with the 10th step in the first approach. Because that's what this bill actually provides, that a policeman must go to handle a public order or a public demonstration fully armed for a war.
Right.
So that he can actually fire at any time.
Maybe they don't have time. They don't want to waste time doing that. They want to deal with the riot so they can go and do more important things. This is Spectrum listeners on Radio 1. Tonight, what are the specific clauses in the Public Order Management Bill that need to be struck out or amended in order to have a law that is acceptable? You can call in now on numbers 0414 348 111 0312 260390 0312 261390. When you call in, please tell us your name and where you are calling from. Spectrum, hello?
Edmond, good evening.
Good evening, your name?
Yeah, thanks for the guests in the studio for a very insightful discussion. My name is Jimmy.
Yes.
Every sane Ugandan knows that corrupt and any dictatorial regimes will tend to use the law or make laws that do away with any peaceful, lawful gathering that is in any sane community. I want to thank the colleagues in the studio for having opened up the whole essence of why these guys are trying to figure it out and how they want to go about it. Surprisingly, the IGP is not only a well-exposed and informed legal learner or scholar, but at the same time he knows, or he should have known, that there was something called apartheid, and he knew what happened there. I think he's already enough to know that. But if it's the same IGP whose family lives here, whose descendants will live here, and is part of the system that wants to deal away with the good of a polity, of a classified society of maybe, well, in the line of democracies, then I'm very sorry for him. Good evening otherwise.
Spectrum, hello? Hello? Alright. Tell us your name and where you're calling from. Hello?
Hello?
Yes, sir, your name?
Yes, my name is Gerald Okwari.
Gerald?
Calling from Kampala.
Could you switch off your radio or walk away from it?
Okay. I'm not going to talk from a very legal perspective, but plainly speaking, I think the laws that are being drafted now, especially the public order bill, is basically to suit the current government. And they should take very careful steps in whatever they're doing, because supposing they lose the next election, it will definitely mean that this law is going to catch up with them. So it is not done in the interest of the people per se, but it's done in the interest of those who are in power. It's like building a prison that is providing very, very poor services, extremely pathetic services. Then before you realize, you're the one going to prison next. I'm sure you'd not like to be in such a situation. So to me, it is not done in public interest. Whatever is done in public interest should be able to take considerations of each and every Ugandan, and meaning each and every Ugandan, meaning even these people in the ruling in power.
Spectrum, hello? Hello? Yes, sir, your name?
Hello?
Yes, your name?
My name is Gerald.
Yes, another Gerald.
I would like to comment specifically about this issue of rioting and demonstrations. We've had several demonstrations which are riotous and chaotic. I haven't heard anybody talk about the fire, the stones, blocking roads. These are some pieces of evidence that show that there is disorder whenever there is a public demonstration.
So this law probably, if put right, like they suggest, could help us reduce such incidences. Secondly, about Article 92 of the Constitution. Yes, it's true you cannot make law change or vary the court decision. But we should remember that in that case of Mwanga Chivombi, what was nullified was Section 32.2, which was specific about permission to demonstrate. But it did not nullify the requirement to regulate, which is provided under Section 32, Clause 1, Subsection 1. So, if this bill is properly placed to regulate, I think it could be a good law.
Spectrum, hello.
Yes, good evening, Edmond.
Good evening to you. Your name?
This is Fred. I'm talking from Kisumu.
Fred Kisumu, yes.
I salute the guests in the studio. I thank them very much for their articulation. But my brother Opiyo mentioned something about handling a riot. I imagine a policeman going to handle a riot without a gun, without a baton. I don't know whether that policeman will have his life, especially looking at our people in town here, these guys in town here. Remember when we were playing with the Kenya, what these people did to the policeman? So, it's important to handle riots in a professional way, as a force, but also, let's be mindful of this problem. Thank you very much.
Spectrum, hello. A final caller. Hello. Okay, we don't see him. Hello.
Yes, Spectrum.
Yes, sir, your name?
Good evening, Spectrum.
Good evening to you.
Dr. Kim Tokambo is my name.
Yes.
I salute you this evening. I just wish to thank the guests for their wonderful articulation, and thank you for the moderator for the program. Have a good day.
Well, thank you very much. We'll get back to the studios. Sophie, talk to us about policemen. They can't show up wearing slippers. They have to be quick.
Yes, I also wondered about that. But I think here we are caught up in a catch-22. The police is actually supposed to be a civil police, where it is much more closer to the people, the civilians. It's supposed to be civilian. But we have a police that is already militarized, and many of their practices are militarized. So in that perspective, we are not sure whether our police is a civilian police or a militarized police. So we get into this catch-22.
Give us more detail on that. Civil versus militarized. What is a civil police supposed to be like?
A civilian police is a police that is more about protection of the people. Engagement of the people. The whole bit about the roles defined in, for instance, Mwanga Chivombi, on what the role of the police should be in such a situation of a riot, is what a civilian police is. And a civilian police does not engage in fights with the people, in battles with the people. You know, a civilian police creates an environment that allows the people to express themselves, to enjoy themselves, even to assemble or even to associate, you know, creating an environment that allows that, you know, as a civilian police. Many times you find that a civilian police would engage in even the discussions and the dialogue that my colleague is mentioning, you know. But a military police, a militarized police, comes out with a force as a military, you know, in the army. There's no room for negotiation. Frontline is frontline. The rules of the frontline are the rules of frontline. You go to the battle, you fight. You do not engage in talk and discussion, no. Which is a different mindset. It's a different mindset.
The military mindset has been brought into the
now we caught in between, because we should have a civilian police, but probably what we probably are seeing is not so much of a civilian police. That's where we're having a problem.
Interesting. Nicholas.
Yeah, Edmond, you see, let me start with Jimmy, you know, about legitimacy. You know, these are symptoms of a failed state. You know, once you have a state in which parliament is being coerced, you know, to pass legislation, you have people being bribed to pass legislation, you can pass a law, but will that law have legitimacy? Will it receive the acceptance across the country? This bill, in my view, does not enjoy any legitimacy with any people, with any person in this country except people like Kyagulanyi. So you might pass a law, but that law may not be legitimate. You may not enjoy the support of the people. It could be intended to preserve a particular, status quo, but that's only for a short time. Don't forget, history teaches us that when Obote was still president here, he passed the emergency detention law.
Detention without trial.
Yeah. The person who took that law to Parliament, Gracie Bingira, was the first to suffer arrest under the same law.
He paid the price.
When he was being taken to prison, he mentioned these words. He says the law is a double crosser. This very law might be, if passed, might be used to arrest Kale Kaihura or anybody who is in his lot. Now, back to Gerard, that's the intention
his
of
father had issues with the police in the 1950s. Kale Kaihura's father, he was on the wrong side of the law at that time. In the 50s, I think he was arrested over demonstrations regarding transport and things like that.
It's ironical now that his son is the one.
Actually, the one who should have arrested him if he was in that.
Then let me just respond to Gerard. We are not saying police officers must approach demonstrations like a demonstrator. See, a policeman, first of all, is equipped with knowledge. He's trained. A policeman has protective gears. They have bulletproof vests. They have helmets. They have shields. Those should be the first tool of protection to a police officer. The first tool of protection cannot and should not, in any circumstance, be a live ammunition. That is wrong. That offends the Constitution, offends the work of the police, offends every logical thing that we know about the police. Because if you're police prepared to go and confront a peaceful demonstration with guns, with live ammunition, that police is not a civil police. That is a repressive, militaristic, and dictatorial police. Which
repressive,
I think
dictatorial police.
Yes.
So you think this is a problem that will turn
that's what happened in Russia. That's what happened in North Korea. In Gaddafi Libya. It is not what happened in progressive democracies that Uganda aspires to be. So we're not saying the policeman must approach a crowd, dressed in a collarless shirt and a t-shirt, and no. Policemen are supposed to be trained. They have bulletproof, vests. They have helmets. They have shields. Those should be the first tool of approach, not live ammunition. Now, to the second Gerard about the Mwanga Chivumbi case, I agree with you that the court did not deregulate the management or control of public demonstrations. No, it did not. What the court did was take away the perceived right of granting permission by the IGP. And that's exactly what this bill is trying to introduce.
Yes.
And Article 92, which I was looking for, is very clear. And I can read it for you.
Please do.
That Parliament shall not pass any law to alter the decision or judgment of any court.
So this is what this law is. This bill.
That's exactly what this bill is doing.
It's unconstitutional.
It is, in a larger sense of it, unconstitutional. It is premised on a good principle. It is premised on a good desire to control public order. My view is that public order can be managed appropriately under the existing law, particularly Section 32 and 35 of the Police Act. If that law is interpreted properly, what we need to define is the question of notification. What does notice mean? Does it mean administrative permission to grant or to deny? Does it mean it's just notification and the police must then prepare to allow you to exercise that right, to protect you to do what you want to do? That is the point of controversy. We don't need another law. We don't.
And Edmond, in addition, we are not saying that we should not manage public coming together in Uganda. Yes. No, we are actually saying yes, we should manage them. And that's why we are saying that issues around, when he brings out examples of fire and stones, and then those that were using sticks, yes, we're saying those are the culprits that we need to bring under book. But how do you manage it? You don't manage it by taking away what the others are enjoying.
You don't want them to fight fire with fire.
And as such, we are encouraging them, we are encouraging Ugandans. Parliament is on recess. They've broken off for Christmas. They'll be returning in mid-January. As they come to the constituencies, please engage them on this bill. The specific committee that is responsible is the Legal and Parliamentary Affairs Committee. It has already discussed this bill. It opened up consultative processes. They've consulted different people. There are different people who are already on record, but it does not prevent you as a voter of a specific member of parliament to seek guidance from that member of parliament on what his opinion or her opinion is on this bill, and also to voice your concern that you've heard people saying that this bill will curtail enjoyment of certain rights. I think this is the time for you as citizens to also engage your members of parliament on this bill.
Thank you very much, leader. I guess Mr. Nicholas Opiyo, legal consultant at AKIJUL, commentator on political and social issues. I don't think we could get a better person to discuss this tonight. Ms. Sophie Kyagulanyi was our second guest. She's the research and policy analyst for governance at ActionAid Uganda. Thank you very much for tuning in. I've been your host, Edmond Kizito. Spectrum will return tomorrow. Up next is the news in English. Do stay tuned.
Excuse me, would you like to hear about the MTN Pili Pili? It has a really long battery life.